Hi, good afternoon, everyone, colleagues and friends and comrades from all over Africa. We are very, very pleased to welcome you to this workshop, which is presented to you by the Litigants Group. Today we're being hosted by the Institute for Human Rights and Development in Africa, the Center for Human Rights at the University of Pretoria, and the Initiative for Strategic Litigation in Africa. I'm Simone San, I'm the Collaborations Manager at ISLA. We're very fortunate to be joined by two of our respected colleagues in the legal and academic field. And this is Dr. Ruth Nekura, Michael Nyarko, and they will shortly introduce themselves. I just want to say that this is a space we're very, very grateful that so many of you have expressed interest. Knowledge is power, and we are always here to always continue learning. And as much as the Litigants Group has arranged the meeting, it is a space for you as well to become informed, ask the questions, make comments, and share as we all learn together. With that, I'll hand over to Ruth and Michael to briefly introduce themselves, and then we can continue with our learning. Thank you.
Ruth, it seems you're muted.
Sure, sorry, can you hear me now?
Yeah.
Great. Welcome, good afternoon, everyone. I'm so excited to be here. My name is Ruth Nekura. I'm a human rights lawyer, I'm a feminist scholar, and I work part-time as ISLA's legal director, and ISLA is part of the steering committee, so hence I'm here. Over to you, Michael.
Thanks, Ruth. Good day to everyone. My name is Michael Nyarko. I work for the Center for Human Rights at the University of Pretoria, where I manage the center's litigation and implementation unit, and I will be doing the presentation this afternoon or morning or evening, depending on wherever you find yourself.
Right. Thanks, Michael. So before we go into the presentation, I wanted to take a few minutes to just give context to our meeting today. We are calling it a virtual workshop. So in that sense, we're really hoping it won't be a webinar where we are just speaking to you, but really that it would be a workshop where you come with questions and concerns as the conversation goes on, so that we can truly make it a workshop, a virtual workshop. We usually have this trainings on the communications procedure on the sidelines of the commission sessions. And as the litigants group, speaking more about that, we thought it would be good to have another conversation about this with all of you. So as you know, most of you, that the African Commission is, one of the oldest and, I'm saying this carefully, but somewhat accessible continental human rights treaty bodies in Africa. And we know that, for the more than 30 years that the Commission has had its mandate, its protective mandate has certainly played a critical role in terms of advancing human rights standards. We've seen decisions that have led to remedies for victims of various human rights violations. We've seen reversal of death penalties, repatriation of thousands of expellees, and a couple of legislative changes in member states. So it's from a place of recognizing that that's a critical mechanism that we can use and a critical site for struggle that we have in this conversation. We also know that despite the existence of these mechanisms, several challenges remain that undermine the effectiveness of especially the protective mandate of the Commission, which is what we'll be focusing on today. A number of communications, the number of communications rather that has been considered and decided on merits, it's still relatively low. There's a lot of delays, in the consideration of communications. There's a lack of jurisprudential cohesion and significant challenges in the implementation of the Commission's decisions. There are also challenges in terms of management and administration of the communication procedure between the Secretariat itself and various litigators or litigating parties. We've heard several challenges in correspondence, acknowledgement of submissions or information, access to information regarding communications, pending communications. And so in response to these challenges, the Litigants Group was formed about 8 years ago, coming up to 10 years actually. And the goal was really to engage in research, discussion, advocacy, to see how the work of the Commission can be strengthened and how the protective mandate specifically, can become more effective and advocacy towards that goal. So the membership of this litigants group is made up of about 60 lawyers and non-governmental organizations who work with or are interested in the protective mandate. And sometime in 2019, you can correct me, Michael, we developed a strategy for the litigants group where we said, okay, we are aware of all the challenges that exist, but it would be nice to crystallize, action points, or what is it that we would like to do in terms of challenging this, of pushing back against these challenges in a systematic manner. And so we developed a strategy, in terms of seeking to strengthen the protective mandate of the Commission by working towards, the existence of a functional and effective communications procedure, which in the theory of change that we were considering is to see that, this, in order to do that, what's needed is greater transparency on how the Commission works, but also greater access to information on the mechanisms, operations itself, timely finalization of cases, and consistent development of jurisprudence and implementation of decisions and provisional measures of the Commission. Part of this work also considered, the link with other coalition or organizing work that has tried to push for an effective commission, for instance, SIAC, which has, tried to push back against the challenge on the independence of the Commission. And so part of mapping the different advocacy groups that are supporting the Commission is an important part of achieving the goal. So just to say upfront that if you are not a member of this litigants group, but you're interested, we do have membership forms that can be circulated in the course of the conversation, so that if you're interested, you can express interest. And towards the end, we'll talk more about, the different types of memberships that we can consider, that rather were conceptualized in the development of the strategy that was shared with our teams as well. So at this point, I'd like to pause and invite Michael, who will go on to make the presentation on our topic of focus today, which is the communications procedure of the African Commission. And thereafter, listen keenly, come through with your questions. You can post them in the chat. We'll also have a time when you'll have the opportunity to be unmuted to speak. So let's really be in this all together. Over to you, Michael.
Thank you very much, Ruth, and welcome to everyone. I have been told to inform you that there is translation, French translation. So if you want translation in French, there is a channel for French which you should be able to access. I'm not exactly sure how the technicalities work on your side, but I can see there's French and English, and usually you'd have to put off the original language so that you can hear the translation clearly. But essentially, I'm going to share my screen. I've got a short presentation, which probably will take us about an hour to go through. And then after that, we would come to a discussion session where hopefully we'll get to interact with the participants and other colleagues who are joining us today. So as I've already been introduced, my name is Michael Nyaku. I'm the Litigation and Implementation Manager at the Center for Human Rights here at the University of Pretoria. And between the Center, ISLA, and the IHRDA, we formed the Litigants Group. And today I'll be talking to you about the communications procedure of the African Commission, specifically taking into consideration what changes have occurred subsequent to the adoption of the 2020 rules of procedure and a directive that was issued by the Commission in 2021, sometime last year. The whole essence of the talk today is to sort of provide participants with a brief background to what exactly it is that the Commission's communication procedure is, how to navigate around the submitting communications before the commission. But before then, I'll provide a sort of a background introduction to exactly what is the African human rights system, what exactly are the components of the commission and its different mandates, and then we'll zone in into the specific protective mandate, which is the complaints mechanism or the communications procedure before the African Human Rights, the African Commission on Human and People's Rights. So as part of the background of the history of human rights within the African Union, or the OAU before it became the African Union, human rights in the immediate post-independent Africa, especially after the formation of the OAU, focused mostly on the anti-colonial struggle, self-determination, so that when the OAU was formed in 1963, a lot of attention was focused on the complete decolonization of the rest of Africa. So the focus of the Organization of African Unity at the time was mostly, at least in terms of the human rights angle, was about self-determination and how to, fight off the colonial powers and to ensure that Africa becomes, or African countries become independent over time. So the formation of the OAU did not in itself come with specific human rights obligations, except a very small reference in the charter of the OAU at the time, which sort of admonished member states to have due regard to the Universal Declaration of Human Rights, which had been adopted almost two decades before the OAU itself was formed and its charter was adopted. But as chance would have it, most African states, just immediately after independence, descended into a bit of chaos, civil wars, military dictatorships, unrest across the continent. So there were a lot of refugee situations across the continent with a lot of internal displacements. So that the first instrument, which one could consider to be related to human rights or humanitarian law in some sense, that was adopted by the African Union, then the OAU, was actually the OAU Refugee Convention relating to the specific situation of refugees in Africa. And that was sort of the main focus of the OAU at the time, because refugees were the main problem of the continent at that point in time. So there was not really a real focus on the broader concerns of human rights beyond self-determination and the rights of refugees immediately upon the establishment of the OAU in 1963 and the years after. The AU, in its new formation, which was formed in 2000 and officially came into force in 2002, sort of brought a new impetus on human rights on the continent, in the sense that the Constitutive Act of the AU now specifically makes human rights one of the objectives of the African Union, that the Union works towards the promotion and protection of human rights in its member states. And in some context, the AU is actually allowed to intervene by use of force in member states if there is a urgent need to protect human rights in a specific member state. In the cases where the state itself is the violator of human rights, or is unable or incapable of preventing the violation of such rights. The so-called Article 4H right of the African Union to intervene in member states. So that in the course of transitioning from the OAU to the African Union, a more human rights focused has been taken by the OAU, and a lot of the activities by the AU, and a lot of the activities of the AU now have a human rights component to it. Even peace and security and politics across the continent these days have been couched under an architecture that looks at human rights as a strong component. But in terms of the forms of human rights instruments that the AU or the OAU has adopted over time, they come mostly in the form of the hard law, which is the treaties and the protocols that accompany the treaties, sometimes as additions or amendments to the treaties themselves, but in many instances also in the form of soft law, declarations, resolutions, guidelines, and every now and then general comments from the African Commission or the Committee on the Rights of the Child, which is perhaps not our main focus here, but the Commission does adopt a number of soft law instruments in many forms, which are the main human rights instruments through which litigants may craft their pleadings, but also the sort of reliefs that they seek from the commission. In terms of the main human rights instrument, of course, there are many more human rights instruments, but the ones that the commission perhaps would be more particularly involved in would be the African Charter, which one could say is the primary instrument of the African human rights system. It's the treaty that establishes the African Commission and provides its functioning and mandates and the whole complaint or communication procedure itself. If you're the first protocol, which is the protocol on the rights of women in Africa, also known as the Maputo Protocol. Of course, there was an initial protocol on the establishment of the African Court, which was adopted in 1998. But because the African Court is not our focus today, I sort of left that out. But in terms of the main, treaties that the Commission would usually be concerned with, you also have the Charter on Elections, Democracy, and Governance. And then there's a number of protocols, including the protocol on the rights of older persons and the one on the rights of persons with disabilities, which in many instances the Commission would receive reports on in terms of the state reporting, but also may form the basis for individuals and NGOs to file direct specific complaints alleging human rights violations of a specific individual or a group of individuals. In terms of the African Charter, which, as I just mentioned, is the basis of the African human rights system, it was adopted in 1981, came into force 5 years later in 1986, and the Charter essentially establishes the African Commission on Human and People's Rights, which has its primary seat in Banjul in the Gambia. As of now, all members of the African Union, except Morocco, have ratified the African Charter. So the Charter sort of has almost universal ratification across the continent. And Morocco, particularly because Morocco left the OAU for almost 2 decades after the OAU recognized the Western Sahara as an independent state, even though Morocco claims that territory as part of territory of Morocco. So because Morocco left the Union for a while, they only returned a couple of years ago, and I'm not aware if they have ratified the Charter as of now, but apart from Morocco, almost every other African state has ratified the Charter. So you could say that the Charter has almost universal ratification among all African states. The African Charter has been described as being unique in a way, in a sense that it was one of the first instruments that did not make a divide between what has become sometimes a very strict division between civil and political rights and economic, social, and cultural rights, per se, because of the wrangling that occurred within the UN in the adoption of the 2 covenants on civil and political rights and socio-economic rights, particularly in the era of the Cold War, when Western states and Eastern states could not agree on what exactly the core human rights that states must abide by. But the African Charter, in its uniqueness, did combine all of these rights, did not provide any specific conditions for the fulfillment of economic, social, and cultural rights. In particular, there's no resource requirements or any of the conditions that are placed on the economic, social, and cultural rights in the covenant, even though the African Commission over time has said that resource implications are important for economic, social, and cultural rights, and therefore, even if there is no specific, explicit provisions in the Charter, you would still have to progressively realize these rights. But in terms of its normative framework, the Charter is unique in that sense that it combines civil and political rights, economic, social, and cultural rights, but also the duties of the individual, in recognizing that rights also come with some duties, and that individuals owe duties to their communities, but also their states and the broader African continent as a whole. The African Commission, which is the supervisory body of the African Charter, is made up of 11 members who are nominated by member states and elected by the Assembly of the African Union. Even though the members of the Commission are elected or nominated by member states, they are supposed to when elected onto the commission, act as independent members who owe no allegiance to any specific state, and therefore they are not supposed to act in favor or contrary to the favor of any particular state. They are recognized as independent experts who have high moral standing and have expertise on human and people's rights to enable them to properly carry out their mandates as the supervisors or the supervisory organ of human rights on the continent. Commissioners serve in their personal capacity and not representative of any particular state, even the state that nominated them. So the commission it's not a permanent body. So it's ad hoc in the sense that it's got a number of sessions within the year. And when it has its sessions, the commissioners would meet in Banjul or in any other location where the sessions are being held. Sometimes member states offer to host the commission sessions within their own states, and the sessions would be held in that particular state if offered by that particular state. So the commissioners are not in Banjul all year round. They only go for the sessions of the commission to perform the mandate that is assigned to them by the charter. And in terms of the 2020 rules of procedure, there are now 4 ordinary sessions of the commission. In the previous rules, there were 2 sessions, ordinary sessions of the commission, with the possibility that the commission might also call extraordinary sessions when the agency was there for such sessions to be called. In these 4 sessions that the commission is allowed to call in terms of the new rules, at least 2 of them must be public sessions, in the sense that these must be sessions where NGOs, individuals, other civil society organizations would be able to actually attend the sessions, these days virtually, to participate in the activities of the commission, to organize side events, to engage with the commission, to present their cases if their cases are coming up for hearing, and to engage in any other activity that the commission is organizing around the session at the time. There's a possibility for extraordinary sessions, but these are on a need-to basis, where there's an agency or where a certain issue has come up and it's within the intersession period where there's no immediate session coming up. The commission or the chair of the commission may call an extraordinary session to address the specific issues of concern. And in all of these extraordinary sessions are usually closed sessions, which are not open to the public. But that's the reason why the commission has now increased the ordinary sessions to 4, so that the public can participate in as many of their sessions as possible. In terms of the mandate of the commission itself, there are 3 main categorizations of the mandate of the commission. You've got a promotional mandate, which would include a sensitization of the public, outreach programs, conferences, promotional visits. The commission goes to country visits to interact with government, civil society, other actors to ascertain a specific situation of human rights on the ground, make recommendations to the various actors with the hope that this could improve the promotion, protection, and the fulfillment of human rights in these particular states. But then there's also the protective mandate, which may include the state reporting, where states are required every 2 years to submit a report to the commission outlining how they have implemented the obligations under the charter. And this state reporting process has a component for civil society, where civil society organizations may present so-called shadow or alternative reports outlining their own version of what they consider to be the state of human rights within the specific country which is reporting at the time. And the essence of civil society participation is to ensure that there's not a one-sided, state-controlled process where states come and declare that everything is nice and proper. Meanwhile, the lived realities on the ground may be quite different. So CSOs have a bit of a leeway to balance the kind of information that the state provides to the commission during this state reporting process. And then within this protective mandate, you also have the communications procedures, which is essentially the interstate communication, where states can file complaints against each other for human rights violations within the respondent states. And the individual complaints procedure, where individuals and civil society organizations also are allowed to file complaints alleging specific violations in a particular state or states. Then there is the process of the special mechanisms where you have the special rapporteurs, working groups, and the process of urgent appeals, where these mechanisms provide certain services with the aim of promoting and protecting human rights in specific countries. Sometimes their roles are thematic, other times they are country specific. So in a sense, you could put the special mechanisms either promotion or protection, depending on the specific mandate they are performing at the time. So in the sense of urgent appeals, for instance, you can say that it's protection because you will be asking a special rapporteur or a working group to write to a particular state to say, well, there's an urgent issue going on here. Can you take care of this particular issue, or can you hold on not executing this particular individual because there's a complaint pending, or that these issues have not yet been sorted out. So the special mechanisms may fall under promotion when they are doing the country visits or writing reports or making recommendations to state, or protection, depending on the specific mandate they are performing at the time. Then the commission also have an interpretative mandate where they may provide an advisory opinion. I say may because it is not a mandatory process, merely because an advisory opinion request is submitted to the commission does not obligate the commission to actually give advice. They may provide an advisory opinion if they deem it right to do so, especially where the request relates to an issue that is not currently before any of the organs of the African Union at the time for resolution. And then in terms of the interpretation, they might also do so through the general comments, the guidelines, the resolutions, and the communication procedure itself. In a sense, elaborating on what specific provisions of the Charter or other human rights instruments mean, with the aim of guiding member states on how to better implement their human rights obligations under the African Charter or other treaty over which the Commission has a supervisory mandate. So now specifically to our aim for this afternoon, morning, evening, or night, depending on where you are, the communications or complaints procedure before the African Commission. So the complaints or communications procedure is perhaps one of the major avenues through which states may be held accountable for human rights violations. And the complaints procedure is important in the sense that, unlike the state reporting process, for instance, where it's sort of a comprehensive review of all the activities, initiatives, legislation, administrative tasks that the state has undertaken to implement specific obligations under the Charter, the complaints mechanism allows individuals, NGOs, to allege specific violations and to seek redress for those specific violations. So that if someone is unlawfully being detained in a particular country, the complaint may be made to the African Commission alleging that their right to fair trial or their right to bodily integrity or autonomy is being violated because they've been unlawfully detained without reason. And the Commission would, after considering and deliberating on the communication, make specific recommendations to that particular state on how to remedy the violation that is being alleged. So in this sense, as I mentioned, there's an interstate communication, which is essentially one state bringing a complaint against the other. This is really not our focus today, but as far as I have been aware of, there are very few of them. I mean, I think the DRC against Burundi, Rwanda, and Uganda is one of the few, if not the only, interstate communications that have been submitted since the Commission actually came into existence in 1986. And this is related to the allegations by the DRC that Burundi, Rwanda, and Uganda were supporting rebels in some parts of the Democratic Republic of Congo to destabilize the country and to cause a lot of human rights violations and havoc across many parts of that country. But the main essence of our talk today, which is the individual complaints procedure, relates to the ability of civil society and individuals to go before the commission, allege violation, and to seek redress for specific violations. And this may be initiated by civil society organizations, but also individuals. The process is quite liberal to the extent that the CSOs who are submitting these kinds of applications do not even need to have observer status before the African Commission, nor necessarily have the permission of the individuals they are submitting the complaints on behalf of. As we will come to see shortly, there are conditions under which such complaints may be submitted without the permission of the individuals. But the process is not very strict, in the sense that access is quite generous. The Commission has this process of allowing complaints on the basis of a public interest, the so-called actio popularis, in a bid to allow as many people as possible to be able to submit complaints to the Commission. The Commission allows, well, not the Commission, the African Charter allows complaints to be submitted against states who have ratified the African Charter, or that particular instrument to which rights are alleged to have been violated. So that if you're alleging a violation of the Maputo Protocol, for instance, you must be sure that the state which you're bringing before the Commission has ratified the Maputo Protocol, or that state has ratified the African Charter, and that the Commission has a personal jurisdiction over this particular state to be able to entertain a particular complaint against that state. So in essence, you cannot submit complaints against any entity apart from a state. You cannot submit a complaint against a company, an international organization, individuals. It is only states who may be respondents before the African Commission when you are alleging violations of human rights. In its recent practice directive, the Commission now has adopted a standardized form which it seeks to, or it encourages applicants before the Commission to utilize. I'll show you the form briefly when we go through the actual processes that must be fulfilled before the submission is made. But the Commission is trying to standardize the submission process, because sometimes there are very lengthy submissions that are made, especially at the seizure state, because the essence of the first submission, which is for the purposes of seizure, is just to make a prima facie case that there is a likelihood that a violation has occurred in a particular state, so that it does not have to be the most elaborate, exposition of all the arguments that can be exhausted, because there is a second process of actually making submissions on admissibility and merits, which may be the more comprehensive submissions that may be made. But there is a specific form that applicants or complainants must now comply with, and I'll show you the form in a few minutes. But that form restricts the complainant to 35 pages, excluding the appendices. But if you write anything beyond 35 pages, the Commission may actually return it to you and ask you to reduce it into 35 pages, so that they don't actually become overwhelmed with lengthy complaints, even though the complainant would have to submit further arguments on admissibility and merit subsequently. The complaint itself is supposed to be submitted in one of the official languages of the African Union. In terms of the practice directive, the Commission says that its working languages are English, Portuguese, Spanish, not Spanish, is English, French, Portuguese, and Arabic. The other languages which the African Union consider to be official languages or working languages, like Swahili and Spanish, have not made its way to the Commission's processes yet. But in terms of that practice directive, the Commission requires that if you're making a submission in English, for instance, then all the attachments or annexes must also be in French. That if you're making the complaint itself in English, all your attachments must be in English. It requires a bit more work on the Commission if they have to go back and forth in between languages on the same complaint. But of course, in situations where it's absolutely necessary to, or that the complainant is unable to afford translation to the other languages, I'm sure that the Commission has a reasonable ways of using their own internal resources to assist complainants in this regard. So when you submit that particular form, which we'll come to see very shortly, the complaint then goes through a so-called seizure process. And this form, this seizure form, would contain the particulars of the person who is making the complaint, which is the complainant, and the signature of the particular individual or organization, but also a statement on whether or not the complainant or the victims want to be anonymous. So the communication itself cannot be submitted anonymously. You must declare who you are, what is your interest is. Are you a victim? Are you the complainant? Or are you submitting on behalf of a victim? But if you don't want your identity to be, revealed to the respondent state because you're scared of backlash or some other form of reprisals, you may, in your complaint, ask the Commission not to reveal your identity to the state concerned to protect yourself. So that process is there that can be utilized, especially in places where your identity might jeopardize your own safety if the state knows who you are and why you're submitting a complaint. And then the complaint must include things like the address for correspondence so that the Commission can actually, communicate with you and be able to inform you if the state responds to your complaint or if there are other matters that need to be communicated to you concerning the complaint. And then a factual background of what are the set of facts that have, led to this particular alleged violations. I say alleged violations because they would only be considered to be violations at the end of the process where the Commission actually agrees that your rights or the rights of the individuals or the victims that you're seeking to protect have actually been violated. And as I indicated earlier, that you don't actually need to have the consent of the victims. Now the Commission in its new rules of procedure says that you must show proof that you have the consent of the victims, except if it's impossible to obtain the consent. And in that instance, you must write an explanation why you cannot obtain the consent. So for instance, if you've got a victim who is incarcerated incommunicado and you don't have access to them, the state or the security forces will not allow you access to this particular victim. You can write an explanation as to why it is impossible to actually get a consent of the individual to file a complaint. Or in instances where you have a great number of victims, let's say there are 20,000 people who are affected by this particular alleged human rights violation, it is almost impracticable to require that you get the consent of every individual in these 20,000 plus group of people for you to be able to actually represent them before the Commission. So that in those instances, you can write an explanation as to why it's not possible or practicable to actually obtain the consent of these victims, per se. One thing that we must also keep in mind is that at a seizure state, really what the Commission is looking for is that you must make a prima facie case. You must allege a violation. You must provide facts that at least, if not completely, gives an indication that some rights might have been violated in the process of all these facts that you lay out before the Commission. So you don't have to have every single proof, every argument lined up. You just have to make a case that is sufficient enough or indicative enough for the Commission to be able to, on the face of that complaint, make a decision that is more likely than not that some violation may have occurred here. And then once it seizes itself of that complaint, it will now require you to submit more comprehensive arguments, and it can make a more final decision at the end of the complaint itself. But one of the other things that have changed in the rules of procedure of 2020 is that the seizure process, which is where the Commission decides to actually accept your complaint, is now an administrative process. Previously, in the 2010 rules, the whole commission would have to sit as a body to decide that your complaint is actually complies with all the requirements, that there is an indication or that a violation has been committed, and then they would actually accept that complaint for proper adjudication, where they now allow you to make arguments on admissibility and the merits of the case. But because that then led to a lot of delays, because the commission only has sessions within a year. The secretariat is there throughout the year. They are a permanent body. They are there, every working day of the week, apart from holidays in the jurisdiction where they're working in the Gambia, and that perhaps that would facilitate quicker processes of the commission being able to seize itself of as many communications as possible, so that under the new rules, if you submit a complaint to the secretariat of the commission, they have 60 days receipt of that communication to notify you whether or not the commission has seized itself of that particular complaint, and that you now have the obligation to make further submissions on the admissibility and merits of the case. If the administrative part of it, which is the secretary's duty, fails in the sense that the secretary declines to seize itself or himself or herself of that particular complaint, then they must refer that the complaint to the commission at its next session for consideration. So even if the secretariat at some point notify you that they have not seized themselves of the complaint, they have an obligation to refer the complaint to the commission itself as a body to consider whether or not there is some merit in your claims, and then the commission will make another decision, more of a review process, to see if the decision that was made by the secretary was right or not, and the commission's decision itself may be also subject to further review if you are dissatisfied with the decision of the commission itself. So if the commission then seizes itself of the complaint, in the sense that now it agrees that you have an actual case that alleges violations, and then you are allowed to make further submissions, they will notify you to make submissions of admissibility and the merits. And this is where you get to make your more comprehensive submissions, which perhaps does not have any specific limits, unlike the seizure process where you have 35 pages to exhaust all the arguments that you want to make. So previously, under the old rules, you would have to first make submissions on admissibility, then the commission will decide on admissibility, and then when that is done, they'll ask you to make submissions on the merits, and then they'll decide on the merits. Now the new rules require that you submit everything together, admissibility and the merits, and then they will decide it at the different stages when the complaints come for consideration. But in terms of how the process itself works, once you submit your pleadings on the admissibility and merits, these will be sent to the state party concerned. The state party has not an obligation, of course. They have a general obligation to comply with the obligations under the charter, including the communications procedure, but they have a chance to respond if they don't want to respond. If they want to respond, because if they don't want to respond, you cannot force them to respond. The commission will just have to make a decision in their absence. But the process requires the commission to transmit your complaints to the state. The state has a number of days within which they have to respond, and then the complainant would also have a chance to reply to the submissions of the state. And at some point, the pleadings will be closed, and the commission will now come to deliberate on the specific arguments that have been made by the parties and make a decision on whether violations have been found or no violations have been found, or whether the complaint is admissible because it complies with all the admissibility requirements under Article 56 of the African Charter. But when you submit a complaint, there's an opportunity for preliminary objections, which may be raised within 30 days of the submission of the pleadings. So when you make a submission, the state may make objections to the kind of submission that you're making. They could say that you've not exhausted domestic remedies. They could say that your complaint is insulting and written in a disparaging language, or that it does not comply with some other requirement of the charter itself, the rules of or the rules of procedure of the commission. That process must be completed, or at least it must be started within 30 days of the pleadings actually having been submitted. But when these submissions are made and the commission is about to consider the specific complaint, you may also ask the commissioner to recuse themselves if you perceive that they have a specific interest in the case, in the sense that they are a citizen of the respondent state, or that they have previously expressed publicly a certain prejudice position concerning the case itself. Of course, it's quite tricky if, let's say, the person is an academic and they have written articles or a book or some other commentary which is publicly available and which makes certain positions clear. It's not very clear how the commission would consider that, but at least that would form a basis to make a request to say, well, we know the predisposed opinion of this particular commissioner, and we don't think that they will be fair to us in this process, or we already know what they're going to decide, and therefore they should recuse themselves because of the capacity in which they have previously placed themselves. Then in the process of considering communications, the commission may join a number of complaints together. So if there are a number of complaints that are submitted against the same state that emanates from the similar set of facts or the alleged similar violations, the commission may combine many of these cases together and decide them as though they are one complaint, because it saves time and resources to address all of these similar complaints together as one, than to have, repeat the cycle over and over again, even though you're going to end up finding the same violations and repeat the same, rulings in the subsequent cases that have been submitted. But also they may disjoin cases where if you submit one complaint, let's say against a number of states, but the arguments or the violations are so diverse that it would convolute the adjudication process itself. The commission may say, well, we're going to separate these parts of the complaint into a whole different case altogether. And that process would take its natural course as well. So you would notice that at each stage, there are a number of timelines that have been indicated, but the rules allows you to request for an extension if it is necessary for you to be given extension to file your pleadings or to make certain applications. But in each case, the commission will not give you an extension of more than 30 days. Of course, the commission tends in many instances to be more lenient to states than to individuals and civil society. So even though there is the opportunity to ask for extension, don't be too keen that they may actually grant you an extension. They may do that, but in many instances, states are more likely to get extensions than the complainant. Also, perhaps because that if you are the complainant and you're the one who is alleging the violation, then there's a more imminent obligation on you to, be more forthcoming and involved in prosecuting your own case. But there's always a process to seek for extension of time if you run out of time and if you need more time to be able to submit your complaint. So after this whole process of seizure, the commission now has what is the admissibility process. And in terms of Article 56 of the African Charter, there are at least 7 requirements that must be fulfilled for the complaint to be deemed to be admissible. So the distinction here is quite clear, that merely because the commission seizes itself of a complaint does not mean that it's admissible. The seizure only means that, we know that you have a complaint, it alleges violations that conform to the African Charter and all of that. But now you must show extra requirements that, for instance, show that you have tried to exhaust domestic remedies, or that the complaint has not already been settled and you're just looking for another forum to try to, frustrate the state or to ventilate your displeasure. But in terms of these 7 requirements, it says that it's similar to the seizure process. You must identify yourself. Who are you and what is your interest in this particular case? But also that your complaint must be compatible with the African Union Constitution and the African Charter. And this simply means that you are alleging a violation of human rights that are contained in the Charter. So this is not a very onerous process. It just means that you are alleging, a violation that is a right that is guaranteed in the African Charter on Human and People's Rights. Also, that your complaint must not be written in an insulting or disparaging language. I mean, this in itself does not mean that you cannot make frank statements. There are many communications where, if someone made, very bold, frank statements and said their rights had been violated or the state was acting in a particular manner, the state will say that they are being insulted. But I mean, unless the extreme attacks at specific individuals within the state, you are allowed to be as frank as possible in expressing how exactly you felt violated, without the state having to simply say, well, because we don't like the language that you used, we think it's insulting or disparaging. But if you use specific language against specific, state officials, that may be considered to be going too far, and therefore, insulting and disparaging. And in that case, they will say that the complaint is not admissible, even though the substance, is valid and you've got an actual, violation against you. So perhaps we want to be passionate and express ourselves freely, but we don't want our cases to be thrown out because, we used language that is too strong and deemed to be insulting by the commission. But also in terms of the kind of evidence which may be the basis for your complaint, the rules and Article 56 requires that your complaint must not be exclusively based on media report. This does not mean that you cannot use media reports as a basis of your complaint, but that you must have other supplementary evidence to the kind of complaints that you're making. Of course, in specific cases where the only kind of information available is media reports, perhaps you can make a particular case for why your complaint is exclusively based on media report. I don't foresee a situation where media reports would be the only way in which you would be able to get evidence to support your case. You can have victim statements, you can have statements of family members or other people who may have personal knowledge of the case as other supplemental evidence, but you cannot use media reports only as the basis of submitting a particular complaint to the commission. And perhaps usually the one aspect that is the most litigated in many complaints is the exhaustion of domestic remedies. That before you can submit a complaint to the African Commission, you must exhaust judicial remedies within the particular state or in the state which is alleged to be the violator of the rights. And in terms of the jurisprudence of the Commission, these are remedies which are available, effective, and sufficient. And the Commission considers availability as that the petitioner or the complainant is able to pursue this particular complaint at a domestic level without impediment, so that in cases where the jurisdiction of the courts have been ousted, or if the jurisdiction of the regular courts has been ousted, military courts are now taking over, basic complaints, criminal complaints against individuals. Those are not deemed to be judicial remedies that needs to be exhausted. If you are fleeing the country for your own safety because you are a target by state officials or even private individuals, you're not required to exhaust those domestic remedies because you would essentially be placing your own safety at risk, in order to exhaust those remedies. If you've been deported from the country, you're not, required to exhaust the domestic remedies because it's essentially placing unnecessary burden on you to exhaust these domestic remedies before you are able to proceed to the African Commission. I put indigent as in poverty in red because there is a bit of uncertainty around whether the Commission would, as a matter of blanket, relief, allow you to submit a complaint if you're poor without exhausting domestic remedies. There are cases in which the Commission has actually allowed indigent or being poor as a basis of escaping domestic remedies. But there are also cases where they have refused, especially where the person is being assisted by lawyers or civil society organizations. And the thinking is that, well, if you've got help to come to the Commission, perhaps you could have utilized that help at a domestic level, and that may have been able to resolve your dispute without having to go to the Commission at all. Because the whole essence of the exhaustion of domestic remedies is to first give the state the first opportunity to resolve the dispute, to be able to provide a remedy for you. And it's only when you're not satisfied or you don't get the kind of remedy that you think is capable of resolving your complaint that you then have to go to the international or the regional mechanism, which is the African Commission. But then there's also the requirement of effectiveness, that the kind of reliefs that are, or the remedies that are available must offer some prospect of success. So the Commission has said severally that you must at least attempt to exhaust domestic remedies. But if there is a clear practice within the state where you know for certain that, there's a precedent, for instance, that says certain remedies are not available, or that the Supreme Court or Constitutional Court has already made a definite decision, concerning a particular matter, you don't really have, reasonable prospect of success, because you go through the court and you fail either ways, because there is a precedent that binds all the lower courts that precludes you from getting the kind of remedies that you're looking for, or from having access to the certain processes. And in such instances, then you're allowed to bypass the domestic system, because you are essentially wasting time whilst your rights are continuously being violated. Then there is the requirement of sufficiency, that whatever processes are available within the judicial system of that state must be capable of redressing your complaint. So that if you are looking for, you're looking to go to the Supreme Court and challenge a particular legislation, but that court has no power to overturn legislation within the state, you would be deemed to have the right to bypass that system, because you will not receive any sufficient remedy from that particular body that is capable of, giving you what you think is the reasonable resolution to the dispute that you have with the state. So in these instances, I elaborate further in another slide. You don't really need to, exhaust that particular requirement of domestic remedies. And then there's a requirement of time, that you must submit your complaint within a reasonable time. In some instances, the Commission has interpreted this to mean 6 months, but this is not something that is statutory. It's been determined on a case-by-case basis. In some cases, it says 6 months. In some cases, it says, well, depending on what the set of facts are, it's willing to give, longer periods. But in essence, you must be aware of the fact that the Commission may actually apply that 6 months rule in some instances, and to submit your complaints as soon as you become aware of, the violations, or as soon as you exhaust the domestic remedies, depending on what your circumstances are. And then finally, that this particular complaint that you are submitting must not have already been settled by either one of the UN mechanisms or any of the other African Union mechanisms that have specific mandates over the resolution of human rights disputes. So this is just an elaboration of what I have just explained about the exceptions to the domestic remedies rule, and I provide some cases or communications from the Commission in which some of these have been elaborated further. So when all of these processes have been completed, you've made your submission complies with these 7 requirements. The commission would then have to transmit these to the state to respond. The process goes back and forth until the commission is now ready to make a decision. And this decision may be by default if the state does not respond to your complaint, or if the state responds to your complaint, then the commission would decide based on usually just the pleadings that you have submitted. The commission, I don't know of many cases where they have actually had a hearing to discuss admissibility. For the most part, they will just look at the papers that you have submitted, whatever the state has submitted, and then to decide whether or not the admissibility requirements have been complied with, and they will make a decision on admissibility, which may be reviewed. So, for instance, if the commission declares that your case is not admissible because you have not complied with those 7 requirements, you have within 3 years to ask for a review of that particular decision. And the review may be submitted if the applicant is able to submit new facts, which was not available to the applicant at the time of the initial complaint itself. And the submission must be made within 180 days. So the 3-year period is literally the cutoff point. After 3 years, you might not be able to ask for a review. But the 180 days is from the date at which you became aware of these new set of facts. So it does not mean that at the end of that decision of the commission, you have 180 days to make a submission. No, when you become aware of your decision was made a year ago, you become aware of the new set of facts today, you have 180 days from today to make those new submissions for review of the commission's decision on admissibility. And in cases where the state does not participate in this process, then there really is a bit of a challenge, because there are times when states don't participate in the process and there's a decision is made against them, and now they want to go on the review just after they have been negligent in not participating in the process. But there are also other kinds of processes which the commission may engage itself in, or which complainants may request the commission to engage in, including an investigative mission. So when you submit a complaint and you think that the commission may benefit from actually going to the ground to ascertain for itself, clarify the facts, to see exactly what it is that is going on the ground, to collect documents, to examine witnesses, or to speak to experts concerning the kind of case that you've submitted, you may make a request to the commission to engage in an investigative mission to the respondent state to collect these set of information, which would enable it to make that particular decision. And the commission may also decide this on its own. So if you want to request it, you may request the commission, but the commission may also decide, even without a request, that because of the nature of the complaint, there's a need for them to send a team to go on the ground to look for documents, speak to witnesses, or to verify the set of information. Also, in the process of making a submission, and any time before the commission actually makes a merit decision, you may make a request for interim measures. And interim measures exist as a preservative, measure of some sort, that if you foresee that the situation is so dire that there will be irreparable harm that may be caused to the victims before the complaint is actually finally determined by the commission, that you may request the commission to make some orders to protect the rights of the victims pending the finalization of the complaint itself. And this is particularly important given the context that we have, that these days it takes quite a bit of time for the commission to finalize complaints. Sometimes it takes up to a decade, unfortunately, in some instances, for complaints to be finalized by the commission. So that if you foresee that there's an urgent need for the commission to act, then when you are submitting your complaint, you must include a request that the commission must make provisional measures, which the state has an obligation to comply with, and which that they must report back to the commission within 15 days after that decision has been made of the measures that they have taken to comply with that particular decision. Mind you, the whole commission does not need to sit to make orders on provisional measures. The chair of the commission is empowered to consult the working group on communications in the intercession period where the commission doesn't have any session. The chair of the commission may issue provisional orders in consultation with the working group on communications, and they don't need to wait for a session of the commission for the full commissioners to meet to take a decision on whether or not to order a state to take preservative action at that point in time. Occasionally, there are times when the commission actually does have hearings. These are not very often because most of the complaints are determined on the basis of the written submissions that the parties would make before the commission. But the complainant, the state, either of the parties may request that the commission actually hold a hearing to examine the complaint, to further, satisfy itself of the arguments that have been made by the parties, or for the parties to provide further documentation, call witnesses, experts to come and elaborate on the things that they have said in their pleadings. This is not mandatory, so the commission may not always agree with you that a hearing is necessary, but there's always the opportunity for the complainant to request that a hearing be called so that the issues can be ventilated further. The hearings themselves are held in private because the commission considers the processes of considering communications to be confidential. So even the pleadings themselves are considered to be confidential, so you cannot, in essence, communicate about the things that you allege the state has done to other people except those who are involved in that process, lawyers, witnesses, and other parties. But the hearing would be private. It will not be a public hearing like you would have in regular courts in national jurisdictions. And anyone who is attending that particular hearing would have to observe the confidentiality, that they will not discuss what it is that is going on before the commission at that point in time. It's quite unfortunate that this is the process that has to be undertaken. We have repeatedly made arguments to the commission about more transparency, but in terms of the African Charter itself, confidentiality is one of the impediments in the process of the commission, and the commission does not really have a lot of leeway when it comes to what kind of confidentiality they must observe regarding the complaints procedure. Under the new rules, there's also specific provisions made for amicus interventions. So as individual civil society, you don't actually need to be a complainant in any case. You can intervene as an amicus because you have got specific interest in a particular complaint. You've got specific knowledge that you want to bring to the attention of the commission. But the aim of the amicus is really to make arguments or to present facts that you think would enable the commission to come to a more informed decision. The process really is targeted in a way that first you must make a request to the commission to be granted permission or leave, as lawyers would usually say that first you must request leave to permission to submit an amicus brief, and when the commission then gives you that permission, you would have to submit a full brief of what your contributions are, which would then be able to assist the commission to come to a more informed decision. But the request that you send to the commission itself has its own limitations. You can only write up to 10 pages as part of the request. So it's pretty short, it's brief, detailing what it is that you seek to contribute to the particular case. The challenge here really is the fact that because of confidentiality, it really is difficult to have access to the complaints that has been submitted, but also the response that has been given by the state. So it really becomes a catch-22 where the new rules of procedure says that when you make an application to intervene as an amicus and it's granted, they will now give you the briefs of the complainant and the state. The question is, how do you get to know even what is going on for you to decide whether or not you need to intervene? In practice, most individuals or organizations that intervene as amicus would usually have been, asked by the applicant or the complainant to intervene because they are the only ones who can actually give you access to the complaint or the response of the state. And these are some of the conversations that the litigant group, for instance, is concerned about in engaging the commission on how to make pleadings at least accessible to anyone who wants access to them on the website of the commission to facilitate the process of people being able to intervene as amicus, because it really serves no purpose if you're being asked to intervene, but you don't have access to the materials that initially actually allows you to make an informed decision whether or not you are capable of making any new contribution to the case beyond what has already been submitted by the parties themselves. But in addition to the amicus submission, you may also intervene as an interested third party, in which case you would become a litigating party before the commission. If you have a direct interest in the case that has already been submitted, or that the outcome of the case may affect you in a way of either bestowing some benefits on you or taking something away from you. In that case, instead of intervening as an amicus who is not really interested materially or personally in the outcome of the case, that as an interested third party, you are intervening because you've got something material to lose or to gain from this particular complaint that has been submitted by another individual or organization. And the commission would notify the parties if you make an application to intervene as a third party, and would decide whether or not you actually have a sufficient basis for intervening in that regard. So we go through the admissibility. You may intervene as an amicus, as an interested third party who has a live, complaint or benefits or something to lose from the complaint. In the end of all of it, the commission must now make a decision on the merits of the case itself, whether or not your rights have been violated, or whether the state has not violated your rights and therefore does not have any obligation to provide remedies or remedial or to remediate those violations. In terms of the new rules, the commission must reach a decision within 1 year when the complaint becomes ripe for a decision. Essentially, when the pleadings close, they have a year within which to actually make a decision and to inform you of the outcome of your case. It's been almost 2 years now since the new rules came into existence. I've not really tracked the complaint process to see if the commission is actually sticking to this 1 year process. But the whole essence of these new rules is to ensure that the complaints process does not take forever, that your complaint does not stay in the commission for a decade, whilst your client or the victims or you yourself are the victim of the violation and you're suffering the cost of these violations whilst the complaint is lying in the commission. But in all of this, even where the commission makes a decision and notifies you that they found a violation in your favor, the state is recommended to do certain things to remedy the violations, there is still an obligation of confidentiality in terms of Article 59 of the African Charter, that you cannot communicate that decision to anyone else, apart from your lawyers and other people who were initially involved in the case, until the Assembly of Heads of States of the African Union has met and considered the report of the African Commission within which that particular decision is contained. But in any case, when the Commission makes their decision on the merits, they have 30 days within which they must publish that decision in the sense of notifying the applicants or the applicant and respondent that a particular decision has been made. And in terms of the new rules also, the Commission may decide to hold separate hearings or to make a separate decision on the reparations and cost, so that even where they found a violation, they may decide, we found a violation, but we don't have sufficient facts to decide what is the appropriate remedy, or how much compensation is due to this particular individual, or what kind of law reform or administrative action may be more appropriate in providing a remedy for this particular violation. So they might separate the process into the merits is done, we find a violation, but in terms of the reparation and cost, we're going to have a separate process of actually fleshing out that process, as well. And that's the complainant additional opportunity to specifically explain to the Commission why it wants specific reliefs, or why the applicant has suffered specific harm and therefore deserves to be compensated in a particular way for the violations that it has suffered, which the Commission agrees the state is the responsible entity and therefore must provide remedies for. The merits decision itself is also subject to review, so that either ways, whether or not the Commission finds a violation or not, either of the parties may take it on review. The complainant may review the decision if the Commission finds no violation against the state, if it comes into new sets of facts, within 3 years, similar to the admissibility decision, and that these new set of facts is capable of swaying the Commission in a different direction because it clearly shows the involvement of the state in this particular violation. And these must, similarly to the admissibility process, be submitted 180 days upon the discovery of the new set of facts. What really the new rules have added to this review process is that if the state does not participate in the process, does not make any submissions at the time when it's actually called upon to, inform the Commission of each side of the case, of whether or not it agrees that it's violated the rights of the individuals or the groups that are alleging violation, then it's actually precluded from asking for a review, because essentially what the state is doing in this instance is to say, we don't want to participate, but if you make a decision and we find it unfavorable, then we deem that we have a right to have that decision reviewed. The Commission would only under very special circumstances allow a state that has not participated in the process to take that same decision on review, because it is unfair to the complainants that they go through this whole process, the state ignores them, and when the violation is found against the state, then the state all of a sudden realizes that, well, there's a cost to pay for non-participation, and they want to take the case on review. So if you're a complainant and the state ignores you, you are entitled to go for default judgment. And if you go for default judgment, you must resist every attempt by the state to take that case on review, because they might provide special circumstances that precluded them from participating in the initial process for them to actually be able to request a the commission to reconsider the decision that it has made. So in some sense, the new rules have sort of streamlined the process a little bit to the extent that it responds to some of the complaints that stakeholders have over the years made against the commission per se. I mean, we, for instance, have said that the commission has always been more favorable to the state parties. They're more lenient to the state parties. They're always willing to give them extra time. Meanwhile, they don't extend the same kind of courtesies to the individuals or civil society that are perhaps the primary users of the system, because they're the ones who are almost all the complaints and putting the commission to task to adjudicate on these kinds of complaints. So there's been a bit of streamlining of the process in the new rules of procedure. In terms of the remedies that the commission is able to grant after it's gone through all these processes, there is the process of an amicable settlement where either party may go to the other party and say, we want to settle this amicably or friendly. The state may approach the complainant and say, we agree that these violations have happened. Can we make you an offer? Or can we tell you how we can remedy this decision, this particular violation? But this must be ratified by the commission itself. So if there's an offer that is made for an amicable settlement, which may also be suggested by the commission. So the commission may suggest to the parties and say, the complainant, respondent state, can you try to talk to each other? Try to resolve this complaint among you, then report to us of the kind of settlement that you've been able to reach. And if we think that it is a fair settlement, we would, ratify that as though it is a decision of the commission, and that the state must then implement that amicable settlement as an order or a decision of the commission itself. But of course, this is not an obligatory process. It's a process that both parties or either party to the dispute must be willing to subject themselves to. And the commission does not have to accept that amicable settlement if it thinks that it's an unfair settlement, or that it's unfairly disadvantages the complainant, for instance, in that process. So even if the parties are willing to settle amicably, whatever settlement is reached must be adopted by the commission as though it is its own decision. And this is sort of a control mechanism to ensure that a complainant who sits in a much less empowered position is not muscled out of the fair settlement by a powerful state, which may use threats and intimidation to force a complainant to acquiesce or to give up on its rights. So that process of amicable settlement is one of the remedies that may come out of a complaint submitted to the African Commission. But then the commission may also make its own findings or recommendations after undergoing through this whole process of receiving the complaint and deliberating and actually making a decision. And in many instances, it will make a declaratory order indicating that it finds a violation of a particular right or rights within the African Charter or other human rights treaty over which the commission has the mandate to monitor and implement. Or it may make specific orders as to compensation, law reform. Sometimes it's even just memory. It's a whole lot of remedies that may be ordered by the commission, because there's no specific remedy that the commission is required to make. They are allowed to make a remedy that is capable of resolving the dispute and remedying the harm that the complainant has suffered if the commission agrees that a violation has occurred. In many instances, they would just make a declaratory order, at least in the past. Now they make more specific orders as to compensation, or there's a broad order that is usually made that the state must bring its domestic law in conformity with the African Charter, whatever that means. But those are, the kinds of remedies that the commission can make. But the complainant must also endeavor to indicate what specific remedies that they seek from the commission. And we're almost at the end. I'll show you the complaint form just after this, so that you see how, in particular, the commission anticipates that if you're making a complaint, what do you need to set out, including what exactly you want the commission to order the state to do, or what you think would be an appropriate remedy to resolve your dispute. In terms of follow-up, usually when the commission makes a decision, it gives the states, in terms of the rules, 180 days, which is 6 months, more or less, to report back to the commission on the specific actions that it's taken to implement this decision. And the commission has also, in terms of its new rules, given national human rights institutions a sort of role in implementing the decisions of the commission. As we all know, national human rights institutions may more or less be sort of the counterpart of the African Commission in our domestic legal systems, and they perform similar mandates within our legal systems as the African Commission. So as counterpart institutions, the new rules allow the commission to actually mandate your own National Human Rights Commission to also follow up with the state on the implementation of these particular decisions that is made to the commission. The commission may also require the state, when it's reporting on that two-yearly state reporting process, to indicate what measures it's taking to implement that particular decision. Of course, there's also the process of legal aid, which I should have probably mentioned much earlier, that if you file a complaint, but you don't have the access to legal counsel or to funds that will enable you to properly prosecute your case, you can make a request to the commission to provide legal aid to enable you to actually be able to prosecute your case properly. The commission also has a complementarity relationship with the African Court.
Michael, let me just interject for a minute. So you have about 3 minutes to wrap up. Yeah, would that be fine?
No, that's fine. That was actually the last slide. So.
Oh, wonderful.
Yeah. So in terms of complementarity, we know the African is sort of the sister institution of the African Commission, and the court, perhaps being a judicial body per se, has some other binding force to compel African states to act in a certain manner. And the protocol to the court allows the African Commission to make complaints before the African Court. So the only way the commission usually make complaints to the African Court is that someone submits a complaint to the African Commission. The commission decides, well, actually, this is a complaint that is serious enough. It involves massive violations of human rights in a particular state, and we think that this is a candidate case which should be sent to the African Court. In the previous rules, the commission could send a number of complaints to the court, including its own decisions that it had made. So if it made a decision, the findings have not been implemented by the state, it could take that particular decision to the African Court for enforcement, for more or less. Now the rule says that the commission can only send cases that it had not decided on admissibility. So in essence, when you're sending your complaints to the commission, if you have any hopes that you want the commission to forward that case to the African Court, it might be important to also write an elaborate explanation why you think this is a good case that the commission should consider sending to the African Court. And in a nutshell, that's a brief overview of the complaints procedure before the African Commission. I'm going to quickly show you how the form looks like, the things that you must look out for when you are sending the complaints to the African Commission. We've spoken about most of them. It's the information of the individual organization that is making the complaints, if there are victims, the names and signatures of the victims and the consent of the victims. And if there is no, if you don't have the consent of the victims, then you must provide a justification for why you are unable to seek the consent of the victims. Here it provides the option for you to choose whether or not you request anonymity, and then you would have to write a justification why you seek anonymity. Then here you set up some quick facts about what it is that your complaint is about, the provisions of the African Charter that you allege to have been violated, the identity of the specific government, institution or organ that you consider to be responsible for these violations. And you must also indicate which other public authority has taken cognizance of the situation you allege. So this would, for instance, relate to the exhaustion of domestic remedies. You filed a complaint before a court, the court made a decision, and the decision was not in your favor, or the decision that you got did not remedy the complaint in a manner that you deem satisfactory. And then here, there's a prayer section where you have to indicate what exactly you think is that or those remedies that, if ordered by the African Commission, would resolve your dispute in a reasonable manner. Then you're allowed to list a number of annexures or attachments in support of the complaint. So in a nutshell, that is a brief overview of the complaints mechanism. I thank you very much for your attention. I will hand over to you, Ruth, for comments, questions, and discussion.
Right. Thank you so much, Michael. Actually, if you could just share the form that you were discussing in the chat box, or if it's a link so that people can have a look at as well, that would be really useful. There's a couple of really interesting questions that have been coming and a great conversation happening in the chat, in the questions box. But for now, maybe let me ask if there's anyone who would like to unmute to ask their question audibly, to raise your hand, and then control and the collaborations team will, take note of who those people are, and then we can give them a chance to speak and just share their comments or questions. So kindly raise your hand. There's an icon at the bottom, and control will be able to give you the mic in a minute. I think as you went through the presentation, Michael, you actually resolved some of the questions that were coming up, in the chat box. So for instance, the question on time, what is reasonable time? And you address that indeed there's no hard and fast rule. So what's important is the kind of 6 months rule that's been put in place, although it's really not hard and fast, but more importantly, that the Commission's jurisprudence in this is unclear. And so it's better to be safe than sorry. And so the ultimate conclusion being that as soon as you're aware, that the complaint should come as soon as possible. There's also a question on when you are listing the frameworks, the human rights frameworks, that you didn't mention the African Charter. And so why is this? Is this because it's understood or assumed that the Committee of Experts has sole jurisdiction on children's rights violations, or what is the implication for the Commission?
Yeah, I mean, I left out the African Children's Charter. I think you've already said it, because it's got its own independent monitoring body, which is the Committee on the Rights and Welfare of the Child. I mean, that does not mean, in essence, that the African Commission itself has no mandate over the rights of children, but you cannot allege the violation of the African Charter on the Rights and Welfare of the Child before the African Commission, because the African Charter on the Rights and Welfare of the Child has a specific body that is mandated to monitor its implementation, and it's responsible to interpreting its provisions. So that's perhaps why I left out that particular charter, because of that reason. I've seen questions about whether or not it is mandatory to utilize the new forms in submission of complaints. It actually is mandatory. So the commission in its practice direction wants, all persons who are submitting complaints as part of the seizure process to use that form, because they want to standardize the kind of complaints that come before them. So if you're thinking of submitting the complaint, you are required to use that form as your primary basis for your submission. Of course, that's only for the seizure process. When it comes to the admissibility and merit stage, that you can use whatever format, form, or structure that you want. But in terms of making an initial application for seizure, that form is the required form that the commission would want you to use to submit.
That's good to know. Yeah. Then there's also a couple of questions about the general utility of the commission. So people are wondering, is there any value really in pursuing, this mechanism when decisions can take too long? Is it helpful to do this?
I mean, I suppose it really depends on what you consider to be valuable or helpful. I think sometimes we undervalue the importance of these institutions in our own context. But if you look at time and how things have changed, since 1981, literally almost every single constitution on this continent reflects the provisions of the African Charter, or at least makes specific mention of the African Charter as one of the treaties that inspires its provisions on human rights. Of course, we don't have a perfect human rights record on the continent. There are many problems on the continent, but at least it provides a basis for advocacy for people to challenge their own government, to say, we have these rights. Would you have voluntarily ratified by your membership of the African Union and by your ratification of this charter? And we demand that you perform certain obligations on our behalf, or that you respect our rights in certain way. Of course, states would not usually give you these rights for free. It is the kind of advocacy, the pressure, the transnational mobilization that that come together to sort of take away that ability of states to ignore, our concerns, that actually forces them to act. So if we were to say that these things don't work in some instances, so we completely would disregard them, then there would never be a point where we would actually derive any benefit from the system. So that no matter how little benefit we think that we can derive from it, I think that it is still worth pursuing, because it is little gains over time that actually cumulatively, lead to change. So my good late professor Hines once said, maybe human rights are not here to take us to heaven, they're just here to save us from hell. So we might not get all the answers that we want in one go, but incrementally we see that in many countries there have been some change, on many fronts. And even where states are crude and cruel, they never say that we don't have an obligation. They will find other justification for the things that they do. They will not say that we will disregard the African Charter, or because they actually acknowledge that they do have these obligations. And perhaps it is our own failure to hold them accountable in many instances that allows them that leeway to go on rampage and do things with impunity. But the more we seek to hold them accountable, maybe the more they would be careful in the way that they act and disregard our rights.
Right. And there's just actually some people who are asking where to get, decisions or read communications or the jurisprudence of the commission. And we've been sharing links in the chat. And it's interesting what you say, because even recently, I think in the Litigants Group, there was, I don't know if it was Ashraf who shared a positive decision that came against Egypt, where the commission gave a good finding around police accountability, state accountability for police violence, and it involved, I think, migrant and asylum seeking people. So even though it took 14 years, you can see the good decision. And I think the more we get to reading the decisions that are coming out, we can see the trajectory, and we also know the Commission has often developed standards that are quite considered controversial, normative standards. And we know that even the attack in terms of the independence of the Commission is because often it has taken a stand on, for instance, abortion, on sexual orientation and gender identity. And so there is progress that's made. And despite it feels like 2 steps back, but truly, like, looking at the decisions, you can see the trajectory, even though for women's rights, of course, we are still concerned that there's not enough coming out of there. There's also a couple of questions around enforcement. So, decisions can come out, perhaps, states are held accountable. You've spoken about the structural interdict, the 180 days reporting back to the Commission, but really, what's the situation there other than, the decisions? What else, does the Commission do, or can it do in ensuring respect for its own decisions?
I mean, the Commission really has very limited means of enforcement. I mean, the only other alternative is the referral to the Executive Council of the African Commission for the political process of the AU political organs holding the states accountable for, the obligations to respect the treaties that they have signed. That rarely, is a process that is followed through. But there's good enough research that actually suggests that states respond more to pressure from within. So for the most part, I think civil society underestimates the kind of power that we have, and the kind of pressure that we can bring to bear on states on some of these things that they take for granted. In many instances, even organs of state have no idea the kind of decisions that have been taken by the state. So there's a decision that is made, there are things that the state is required to do. The African Commission notifies the representative of the state in Addis Ababa. The decision never makes its way to the capital in Nairobi or, Banjul or Accra, so that for the most part, it's also incumbent on civil society to mobilize, to advocate, to utilize every avenue that they can to remind the state that these things are there and that they have these obligations that they are failing to perform. And it's constant advocacy and the reminder of all these initiatives that get states to act. Because if we're sitting and waiting and hoping that voluntarily states perhaps may develop a conscience and starts being, good parents, for want of a better expression, then we might not achieve a lot. But that we must constantly take up these decisions, use them in our programming, use them in our advocacy, criticize the states in our academic writings for their failure to implement this decision, name and shame, and hope that really this would galvanize enough people to be aware. Sometimes it's also about awareness about these kinds of mechanisms. There are very few Africans who actually know that these mechanisms exist, even among lawyers who would be those who are mostly concerned about, litigating and ensuring the rule of law. Very few lawyers are actually interested in regional human rights mechanisms. So the visibility, the ability of these mechanisms to have real biting power at the domestic level perhaps also depends on how much people know about them and how much people perceive them to be institutions whose words or rulings should be enforced and obeyed, and how much we are holding our governments accountable to respecting these kinds of decisions. Because if it is just me and you and our organization that knows about this, we're just a small minority. And our role perhaps is to involve more and more people in these processes, and that perhaps may cause some change.
No, certainly, hence this conversation. Over to you, Sarah. I think Sarah had a question she wanted to unmute and speak. Yes, go ahead.
Hello, thank you very much for giving me the floor. Thank you very much, Michael, for your presentation. It was very enlightening. My name is Sarah. I work as a human rights officer for the Committee for Justice. So we already tried to work with the African Commission. Unfortunately, we never really received answers to our submissions. So we really turned to the special procedures of the UN. So I have two little questions, because I really believe that the African Commission can have a bigger and better impact as it's more regional. So it will be more effective to reach our goal in terms of human rights implementation and decisions towards states members. And I wanted to know, as a comparative perspective, do you think that creating subgroups within the Commission, subgroups that would be specialized in different human rights violation, would make our submission more effective in terms of like communicating with the Commission? For example, I will give the example, of course, of the special procedures, like creating a group for enforced disappearances or arbitrary detentions, etc. And my second question to you, Michael, is that do you think the lack of transparency of the Commission has made people less trustworthy towards the Commission, and those use it less than other regional and mechanisms? Thank you very much.
Yes, no, thank you, Sarah. I think for your first question, those subgroups actually do exist in the form of the special mechanisms. There are special rapporteurs that are either thematic or country specific. There are also working groups that have specific mandates on different themes. I'm not sure if there is a special rapporteur or working group on enforced disappearances per se, because I don't think it's been one of the biggest issues on the African continent. I know there are working groups on different issues, but yeah, those kinds of groupings exist within the Commission area. For instance, I have a working group on communications, which has the primary objective of actually, looking at the complaints that we would submit to the Commission. In terms of the confidentiality, we have also been equally, concerned about the issue of confidentiality, because we think it obscures the whole process. It makes it, less appealing to people who, for a human rights institution, would want to see more openness, more transparency. And sometimes our request has been as basic as not even, public hearing for the complaints, but just making the pleadings available on the website of the Commission, so that people who are interested can read, decide whether or not they want to be, amicus or interested party, because it completely discourages, those kind of third-party interventions. For me to know if I want to intervene in your case, for instance, the one that you were mentioning, I would have to come to you and ask you to share the pleadings with me. Meanwhile, if it was available on the Commission's website, I could simply go to the Commission's website, read the pleadings, decide this is actually a case that I have some expertise or interest in, and I can contribute to it in a particular way. Many times when I have been personally involved in intervening as an amicus in cases, it's because someone else who is involved in the case reached out and said, there's this case that we've been working on, and we think that the organization has the expertise and they can make, additional contribution to the case itself. Otherwise, we probably would have never heard about the case. So transparency has affected the Commission's process in a lot of ways, and has perhaps prevented, many people who could have contributed to the quality of the decisions that come out of the process to completely be excluded, because you don't have access to the material that actually enables you to first gauge your interest and expertise and to decide whether or not it is worth intervening in the first place. So I agree with you that there's really the need for more transparency. There's really the need to open up that process to more public scrutiny, also because it helps guard against, underhand dealings behind the scenes. There are some instances where complainants have been quite dissatisfied that we thought a particular decision was made, but the final decision that came out is completely different from what we are aware of or were notified previously, or that a decision went to the Assembly of Head of States and certain portions were asked to be taken out of it because the political organs were not, satisfied with what it is that the commission did. So transparency would really, I think, bolster the process, make it fairer, and make more and more people interested in actually contributing to that particular process. And we have really been trying over the past couple of years to engage the commission in that regard, to at least consider pleadings as not part of consideration of anything in the charter. It's just what the parties have written. It's not anything that the commission is considering, and that those at least should be available to people who are doing research, for instance, or who want to intervene as third parties, and whose work would be made much easier if they could only have access to those kinds of pleadings. But yeah, I completely agree with you.
Thank you. Right. I've pasted in the chat to that question a paper that we wrote to that regard, to that challenge of confidentiality. And really, because what Michael is saying is it becomes like a secrecy. So the lack of transparency means, yeah, that information is only accessible to a few who are connected, or really big NGOs, or people who are already kind of knowing people, meaning that for a majority of civil society organizations that should use the mechanism, organizations that are not well funded or not big, which, as you've seen, Michael said, the commission has very accessible procedures really compared to any other. So those people who could be using the mechanisms, who could be coming as amicus or even filing complaints, then don't manage to because of the whole lack of transparency. Is there any other person who wanted to speak, to unmute and speak? We have about 5 minutes before we close. Control, is there any other hand that went up? Okay, as we wait to hear, Michael, there's also this question on exhaustion of local remedies and how that's sometimes conflated when states will say that, no, the commission is acting like an appellate court as opposed to a regional mechanism. Do you want to speak to that?
Yeah, I think states make that argument all the time, everywhere, before the commission, before the court. It's like they repeat that argument all the time, and every time they're thrown out, but they still repeat those arguments. And I think it's because the states sometimes fundamentally misunderstand how the regional mechanisms work, because that particular case has gone through the judicial ranks in the domestic setting, does not preclude a regional or international mechanism from reviewing that decision. So in that sense, you're not going to the commission and saying, well, in terms of the constitution of Ghana or Nigeria, my rights have been violated. That's completely irrelevant to the commission. You're going to the commission to say, this state has an obligation under the African Charter. And in terms of that obligation, I do not think that I have been fairly treated by the court, by the police, by whatever particular state entity. So you are measuring whatever has happened within the state as against the obligation under the African Charter. It's not, you are not reviewing what they have done, which would have been in accordance with their own domestic, judicial legislative arrangement. You don't go to the commission to allege a violation of your rights under the constitution of your country. That might be something that the commission might consider as background information, but really, what the commission is doing is to say you have an obligation under Article 1 to adopt administrative legislative measures to ensure the implementation of the right to fair trial. And the right to fair trial includes the obligation to provide legal aid when people are facing serious criminal charges. And if you don't provide that within the domestic system, then you have violated the right to fair trial. And you cannot come and say that, well, our court said you don't have to provide legal aid, and therefore you are overturning the decision of our court. In essence, the state is the one that has the obligation. It's the whole state as an entity. It is not specific, organs within the state. So that the decision is a decision that must affect the whole state as a whole. It is not that the commission is reviewing or you are not appealing against the decision of the court per se. you are appealing against the conduct of the state, which in this essence is being perpetrated by a particular organ of that state. So I know the states make that argument all the time, but I don't think there's been any instance where any international or regional mechanism has actually agreed with any state that you can come and say, because this decision was made by our Supreme Court, this is an appeal. Because that is a fundamental requirement, that first you must exhaust those domestic remedies before you can even go to the commission. And then when you exhaust them, they come and say, but you are appealing. And that really is a misunderstanding of how the the system works beyond the state. And I don't think any state will succeed in making that argument. In all the rulings I've seen, they've lost in every one of them.
Right, absolutely. We have 1 minute to go, and I want to take this time to give more information about joining the Litigants Group, where the conversations like this will keep happening. You can send, so they are putting in the chat the email address of Cynthia there. So cynthia@theisla.org, you can send an email to Cynthia and express interest, and then the membership forms will be shared with you on email for those who are willing. And as we mentioned, the Litigants Group is a group of people who are civil society organizations, NGOs, or even individuals, experts, litigators, or people who are interested in using this communications procedure of the African Commission. And there's also working groups in there where we are essentially forming to say, because civil society organizations also need to organize in working groups, right? And Michael spoke about the working groups that exist of the Commission, but it's really important also for civil society organizations in our own advocacy and mobilization to come together, whether it's on thematic issues or a certain output or a specific issue. It might even be temporary, like an attack that has happened on the Commission that we want to galvanize around, or more long-term in terms of tracking jurisprudence in a specific theme. So you're very welcome to join the working groups, or even to propose and start a working group related to your own area of expertise. After the webinar, we'll also send more information just in terms of contacting the Litigants Group, and also the link to the webinar. And we can, if you express interest, then we'll be able to share those forms with you, and you'll be on our mailing list. So that's it from me. I don't know if Michael, you have any last words?
Well, not last words per se, but I mean, only to say that we're all interested in ensuring that, I mean, in particular, the communications mandate of the Commission becomes more utilized, more visible, and more effective, because over the past decade or so, it seems to have become a bit more docile and the least progressive part of the Commission's mandate. And we encourage as many people and organizations as possible to, utilize the system, but also join us in the Litigants Group to at least be able to engage with the Commission towards the kinds of reforms that we want to see, so that these will become an organization or an institution that works for the benefit of, those who most require its services for the promotion, protection, and fulfillment of human rights on the continent. And as many of us as get involved in this process, we hope that would perhaps galvanize some pressure, and that we can see some changes being made within the processes and procedures of the Commission, for the benefits of the African people. But otherwise, thank you very much for your time and for your participation, and hopefully we will engage on other platforms very soon.
Thank you. Bye. Thank you so much, everyone, for joining us. Have a wonderful evening, afternoon, morning. Bye.
Thank you.